Mr. Gondik, are you there?
Yes, Your Honor. Can you hear me?
Yes, I can. Ms. Mitchell, can come forward. And Ms. Mitchell, you were aware your attorney was going to appear by video, is that correct?
Yes.
Okay. Let me open the 24 CF 137, State of Wisconsin versus Eliza Mitchell. The state appears through District Attorney Kevin Schmidt in person. Ms. Mitchell appears in person with counsel Jacob Gondik by video conferencing. We're set here today in this matter for the plea part of this case. Ms. Mitchell, you're appearing in person and your attorney's over there on the left on that big monitor. Off the record, you indicated that you knew and you approved of your attorney appearing by video for this very serious plea hearing. Is that correct?
Yes, that's correct.
And can you pull the microphone a little bit to you so I can just hear you better? Thank you. And now you understand you have the right to have your attorney here to be seated next to you, especially if that would make you feel more comfortable or if you have questions and you need to speak with him. Do you know that you have the right to enter a plea and have your attorney and every other party in person with you?
Yes.
But are you okay with your attorney appearing by video conferencing?
Yes, I'm okay with that.
If at any time you have any questions or you have any concerns and you need to speak with your attorney, let me know immediately and I will adjourn the hearing and I will either let you go outside and give him a telephone call or I will let you go to our Zoom room and I will put you into a confidential breakout session, okay?
Okay, sounds good.
And if at any time you can't hear or see your attorney, let me know that too, because I don't always look at that monitor. I look at my monitor and sometimes they're different. So let me know if that happens so I can make sure you've heard and you've seen everything that's happening today, okay? All right?
Yes, Your Honor.
And I know that this is probably a situation where it's causing a little anxiety because you're in court and this is a very serious case. But I am going to need you to speak up. So not only can I hear you, but so my court reporter can hear you too, because everything needs to be taken down on the record, okay?
Yes, Your Honor.
Okay, thank you. Mr. Gondik, the parties have reached an agreement in this matter. Can you please recite the agreement for the record?
Yes, Your Honor. In regards to count one would be amended to in operating with a restricted controlled substance first offense guidelines. For the sentencing portion of it, it'd be a joint recommendation for a $911.50 fine, inclusive of court costs, plus a 6-month license revocation. In regards to and my client would be pleading guilty to that amended count one. In regards to count two, Ms. Mitchell would also be pleading guilty. That is homicide by negligent operation of a motor vehicle. As far as sentencing purposes, the state would be agreeing to cap at the pre-sentence investigation report recommendation. Both sides are free to argue at sentencing. Count three, as pled in the amended criminal complaint and information, would be dismissed but read into the record.
All right. So, Ms. Mitchell, you understand what's just been stated on the record here?
Yes, Your Honor.
And that is the offer that you've received from the state of Wisconsin?
Yes.
Or that's the negotiated agreement that you and your attorney have reached with the state of Wisconsin?
Yes.
Okay. I do have in front of me a plea questionnaire waiver of rights form. And what I'm going to do right now is I'm just going to print this out here because it looks like you don't have a physical copy with you. So I'm going to print it out for you. If you want to come over here and come and get the copy, please. There you go. Now you have that plea questionnaire waiver of rights form in front of you. Is that the form that your attorney went over with you?
Yes, Your Honor.
And if you flip to page 2, is that your signature?
Yes, Your Honor.
Now, did your attorney go over this document with you thoroughly?
Yes.
Did he essentially go over it word for word?
Yes.
And so you understand everything completely?
Yes.
And if you didn't understand something, did you ask him to explain it?
Yes,
And he did so?
he did.
And on that document, I know it's kind of confusing when you look at it because he just listed the statute at what you would be pleading to. But that is count 2, the homicide by negligent operation of a motor vehicle, a class G felony. Do you understand that?
Yes, I do.
And he didn't put on there the OWI first with the restricted controlled substance as part of the agreement. That's a forfeiture. That's a ticket. And you understand that?
Yes, I do.
And that's part of the agreement that's going to be amended and you're going to plead guilty to that. Is that correct?
Yes, Your Honor.
Formal motion to amend count 1.
So made.
Granted. Now, Ms. Mitchell, it says you're 20 years old. You have 11 years of schooling. You can read, write, and you understand the English language. You are receiving treatment for a mental illness or disorder. What kind of mental illness or disorder are you receiving treatment for?
My anxiety and depression.
Anxiety and depression. And you're not taking any medications for that?
Not currently, no.
Not currently. Now, with your anxiety and your depression, I know being in court is a little anxious. Are you in a position where you can fully comprehend and you understand everything that you're doing here today?
Yes.
Okay. All right. And other than that, no alcohol, drugs, or medications?
No.
Did your attorney go over with you what the state would have to prove your guilt beyond a reasonable doubt as to count 2?
Yes.
Did your attorney go over with you what the state would have to prove for the OWI forfeiture? And that would be by clear, convincing, and satisfactory evidence?
Yes, Your Honor.
Okay. Now, because you're charged with crimes, you are entitled to constitutional rights, and they're right there on that first page of the plea questionnaire. And I'll briefly go over those with you. But did your attorney thoroughly go over those rights with you?
Yes.
And do you understand them completely?
Yeah, I do.
And do you understand that you're going to be giving up those rights?
Yes.
You'll no longer have the right to a trial. You'll no longer have the right to have your attorney cross-examine the state's witnesses or call witnesses to testify for you. You will no longer have the right to testify on your own behalf or remain silent and not have your silence used against you. You will no longer have the right to have that jury trial in which 12 of your peers would need to reach a unanimous decision as to your guilt or find you not guilty. And you would also lose the right to have the state prove your guilt beyond a reasonable doubt. And that's for count 2, that would be the homicide by negligent operation of a motor vehicle. Do you understand those rights that you're giving up here today?
Yes, Your Honor, I do.
And with that OWI first, the restricted controlled substance, the constitutional rights you're giving up are slightly different. You'd be giving up most of those rights. The difference here is you would only have the right to a jury of 6 of your peers, and only 5 out of the 6 would need to reach a decision by clear and convincing and satisfactory evidence. Do you understand those rights that you're giving up?
Yes, Your Honor.
Do you also understand that if you're not a citizen of the United States, your pleas could result in your deportation?
Yes.
Now, if we look at the plea questionnaire waiver of rights form, if you look at that, it has attached to it the jury instructions, and that's essentially what the state would need to prove to the jury to prove your guilt beyond a reasonable doubt. Did your attorney go over that with you thoroughly?
Yes,
And do you understand that?
I do.
And did he go over the maximum possible penalties with you?
Yes.
And so you understand that as well?
Yes, I do.
So now with the OWI first, the state would have to prove you operated a motor vehicle while under the influence of an intoxicant, a restricted controlled substance. And this is your first offense. Do you understand what the state would have to prove?
Yes.
And here there could be minimums of a minimum of a $300 fine all the way up to maximums. And I believe the maximum could be, I think it's an $1,100 fine. But do you understand that there's an agreement reached between the two?
Yes, Your Honor.
You understand that with that, I could say, you know what, I'm not going to follow the agreement with the court costs and fees that they've assessed? Do you understand that?
Yes.
Okay. Do you still want to proceed and plead guilty to the OWI first?
Yes, Your Honor.
Now, with regards to count 2, homicide by a negligent operation of a vehicle, the state would have to prove on or around October 4th, 2023, in Burnett County, Wisconsin, you caused the death of victim 1 by the negligent operation of a vehicle, a Class G felony. Do you understand what the state would have to prove?
Yes, Your Honor.
And do you understand the maximum possible penalty could be a fine of up to $25,000 or imprisonment of up to 10 years of incarceration or both?
Yes, Your Honor.
Do you also understand that the agreement here is for the court to order what's called a pre-sentence investigation report? Do you understand what that is?
Yes.
And that is a document prepared by the Department of Corrections that will provide the court as well as the attorneys with a whole bunch of information about you and about your life. And it will include your criminal history if you have one, and your mental history, your education history, your work history, all of those types of things. And at the end, it will also provide a recommendation for a sentencing from the Department of Corrections viewpoint. Do you understand that?
Yes, I do.
Do you understand that I'm not bound to follow that recommendation?
Yes.
And do you understand that the agreement here between the parties is that it's a free to argue, but the state's capped at whatever that PSI, that pre-sentence investigation report's recommendation is? Do you understand that?
Yes, Your Honor, I do.
Now, do you understand that I'm not bound to follow the recommendation and argument of the state?
Yes, Your Honor.
And do you also understand I'm not bound to follow the recommendation and argument of the defense?
Yes, Your Honor.
I would be free in my own discretion to sentence you to what I believe based upon the facts and the circumstances and the totality of the matter, and to sentence you to what I believe would be an appropriate sentence. Do you understand that?
Yes, I do.
Do you still wish to proceed and enter a guilty plea?
Yes, Your Honor.
Do you have any questions for the court or for your attorney before I proceed?
No, I don't.
Did you go over that criminal complaint with your attorney? And that's that document, the original charging document that basically says what happened that day and why you were charged with these crimes.
Yes.
For the most part, are those facts accurate?
Yes.
Are you admitting here today that you in fact did operate a motor vehicle while under the influence of an intoxicant or a restricted controlled substance?
Yes.
And this would be your first offense?
Yes, Your Honor.
Are you admitting here today that you in fact did operate a motor vehicle and your operation of that vehicle was negligent?
Yes, Your Honor.
And the negligent operation of that vehicle did cause the death of victim 1?
Yes, Your Honor.
Mr. Gondik, may the court use the probable cause section of the criminal complaint to find a factual basis along with the statements made by your client?
Yes, Your Honor.
Has anyone made any threats or any promises to you for you to plead guilty to this charge?
No, Your Honor.
You're doing so freely and intelligently. That means you're telling the court that you fully understand what you're doing here today
Yes.
and voluntarily.
Yes.
Has your attorney represented you competently?
Yes.
Has he answered all of your questions?
Yes, he has.
Has he looked at these matters, at this matter fully?
Yes.
Has he discussed the discovery that's the evidence in this case with you?
Yes.
Has he discussed a potential for any defenses or a lack of defenses in this case with you?
Yes.
Have you discussed with him all facts that you know to exist about this case with him,
Yes, Your Honor.
including any potential defenses you think you may have,
Yes.
or any alibis or other information?
Yes.
Are you satisfied with his services?
Yes.
Do you have any questions for the court or for your attorney before I proceed?
No.
Mr. Gondik, do you believe that your client is entering a plea freely, intelligently, and voluntarily?
Yes, Your Honor.
Do you believe she fully understands the rights that she is giving up here today?
Yes, I do.
Do you believe that she fully understands what the state would need to prove and the facts based upon the evidence that you have reviewed with her?
Yes, I do.
Do you believe that she is competent to enter her plea here today?
Yes, I'm confident she is.
Then as to amended count 1, OWI first, restricted controlled substance, how do you wish to plead?
Guilty.
As to count 2, homicide by a negligent operation of a vehicle, a class G felony, how do you wish to plead?
Guilty.
The court will find your pleas of guilt are done knowingly, intelligently, and voluntarily. I'm going to find that you understand your constitutional rights and what it means to waive and give up those rights. I'm going to find a factual basis to accept your pleas of guilt. Based on that, I will find you guilty of those 2 counts. A judgment of conviction will be entered today. The court is going to sentence you to the OWI first. I will follow the recommendation, $911.50, 6-month revocation of your driver's license, OWI assessment, OWI AODA assessment, and follow through, including the driver safety plan. The court is going to order a pre-sentence investigation report, long form. Agent does not need to be present, but needs to be available by telephone in case any questions arise. This needs to be an in-person sentencing with all parties. Let's get a date and time.
Your Honor, I also potentially plan to have an alternate pre-sentence investigation report conducted as well in this matter. Would the same requirements be of my alternate pre-sentence investigation report writer that obviously he or she could appear remotely by phone? And I suspect they'd have to follow the same deadlines that this court makes in regards to when the reports would be submitted.
Yes. All
Thank
would
you.
be applicable. Victim witness coordinator, can you come up here just so I can hear and so the court reporter can hear? Are there going to be victim impacts?
Yes, Your Honor.
Do we know how many?
Between 5 and 20.
I think the court should do a half day.
Set aside a half day, or do you think this could potentially bleed into more time than that?
I think a half day will probably be enough. But I defer to Mr. Gondik because I don't know if he's bringing character reference witnesses or how many.
Your
Are
Honor,
you going to have, go ahead.
Oh, sorry about that. My apologies, Your Honor. I suspect what the approach to this from my end of things is going to be to submit the letters in advance for Your Honor's review. Obviously, Ms. Mitchell will be providing a statement in person, but I don't suspect to have the character references in front of you giving the statements. I would just rather have them submitted in advance for your review and for judicial economy purposes.
I could do July 28th at 9.
That works for defense counsel, Your Honor.
All right, July 28th at 9 a.m. We'll block it for the whole morning. Anything further from the state?
No. Yes. The state is not requesting revocation of bond for the same reasons we didn't at the bail hearings. The victim surviving family is requesting revocation of bond for matters related to the impact on them. So I'm putting that on the record.
They're asking for revocation of bond right now.
Yes.
I can perhaps take that up on a different date to hear. And we can have some, and then we can have some victims make some statements at that time, if they wish to do so.
I would also like to be present for that, Your Honor. If that's something that the state is going to be pushing towards, I would ask that we get an additional date for that, and then I'd be there personally with my client if they're going to try to essentially revoke her bail for while awaiting sentencing.
And I believe, and that's why I'm saying it, so that Mr. Gondik can be here in person. with his client. So all could be heard on that. I could do April 23rd in the morning.
Whatever time you select, Your Honor, will work for the defense counsel.
I can't be there for that time.
We can do it on an ADA week, and I could do April 14th in the morning.
Your Honor, I'm going to be out of the office the week the 14th through that Good Friday. I think it's the 18th.
I could do it April 28th.
Got one status at 9 o'clock in Douglas County, but any other time that day would work for defense counsel.
Can you do that Douglas County one by Zoom?
I could attempt to get permission from Judge Kalanick, Your Honor.
Because all I have open would be 9 to 10, and that's where I would be scheduling it. And I believe we may need the full hour. Or I could do May 2nd from 9 to 10.
Of course, I happen to be in front of Judge Kalanick on a full day hearing on May 2nd.
Perhaps Judge Glonick would allow a Zoom appearance for your 9 o'clock, and we can start here at 9:15.
Or you're talking on the 28th
The
now, Your Honor?
28th, yes.
Let's go with that. Yeah. I will try to get the that status conference rescheduled given the severity of this offense as well.
All right, thank you. Anything further?
What time on April 20th?
9:15.
Thank you.
There's nothing.